down with the smooth operation of law. Today we're going to talk about more 1983 stuff. Okay, more Title 42 1983 stuff. I hope these conversations are impacting you guys, and I hope that it's bringing some clarity to your thought and mental frame about protecting your civil rights. So today we're going to talk about, can I sue a police officer for Brady violations, for concealment, doctoring, or destruction of evidence? Can I sue a police officer for Brady violations, right? What is Brady? What is a Brady violation? In Brady versus Maryland, the Supreme Court held that the suppression by the prosecution of evidence favorable to an accused upon request violates due process where the evidence is material either to guilt or to punishment, irrespective of the good faith or bad faith of the prosecution. The Supreme Court expanded Brady, holding the duty to disclose such evidence is applicable even though there has been no request by the accused, and that the duty encompasses impeachment evidence as well as exculpatory evidence. Such evidence is material even if there is a reasonable probability that, had the evidence been disclosed to the defense, the result of the proceeding would have been different. Moreover, the rule encompasses evidence known only to police investigators and not to the prosecutor. In order to comply with Brady, therefore, the individual prosecutor has a duty to learn any favorable evidence known to the others acting on the government's behalf in this case, including the police. There are three components of a true Brady violation. The evidence at issue must be favorable to the accused, either because it is exculpatory or because it is impeaching. That evidence must have been suppressed by the state either willfully or inadvertently, and prejudice must have ensued. All right, so let me give you guys a breakdown in a simple format. If the police have evidence, whether the prosecutor knows about it or does not know about it, if simply you know about it, you can sue for a Brady violation. The Brady violation is a violation where there is evidence that can either be in your favor, it can impeach. Impeach just means it's going to create a scenario where whoever the witness is, the information delivery guy, which is the police, or the prosecution themselves, it is going to take away and weaken their argument on what they are trying to prosecute. A good example of that would be, let's say you have a situation like one of my friends, right? My friend had a situation where there was a domestic violence accusation for criminal threats. He caught his old lady at a bar. That lady at that bar was with another guy. That old lady saw one of his ex-girlfriends. And what had happened is that she, seeing the ex-girlfriend, decided to falsify a claim of criminal threats because she had gotten caught. All she did was see his ex-girlfriend without the individual knowing. That means my friend did not know that she was even at that bar. He did not know that his ex-girlfriend saw his current girlfriend. He was minding his own business. But because his current girlfriend felt that she did not want to have to either argue about it, see him, or risk him finding out and getting upset and dealing with all that drama, she picked up her cell phone and immediately called 911 and said that my friend was there threatening her. Not at the bar, if not had communicated a threat by cell phone. Period. There was no call log. There was no nothing. There was no text. That activated the police to address the matter because there is a penal code in California where the mere fact of somebody speaking a threat is immediate reason to now investigate, lock him up, and he had to pay 10% of a $50,000 bail. The problem with it, this whole matter is that there was never a call. There was never any call logs for said act, or text for said act, or messages for said act. They still arrested him. They still charged him. When my friend was asking for any evidence of the matter, they didn't have any other than the information given to them. He literally had to pay money because someone said he said, and they had no nexus. The request for all evidences was being denied to him because they would not allow for my friend to be able to see the testimonies. He read the paper account, which was the paperwork, but there was nothing on the case record. The prosecutor spent time trying to prosecute him for about a whole year. With that being said, the lack of them being able to produce the evidence and still pursuing him made him produce evidence of his own for his exoneration, for him to prove his innocence. So what were those evidences? Well, here's the deal. It just so happened that the girl had a tablet of his. She also had a restraining order during the time, and they were seeing each other. But irrespective of the restraining order, he was living in a hotel room as a result of that restraining order. He was paying the hotel room. The problem with the hotel room wasn't the room. The problem with the hotel room was the fact that it was evidence against the girl, because that hotel room was in her name. He didn't have an ID. She put up her ID and rented the room in her name. He was there for about a month. So now she has the room in her name. They have CCTV at the hotel with her face. She was just there that day. Now that doesn't prove evidence. But here's what does. That tablet that he had left at her sister's house because they were driving around together. And when he got arrested, she accessed the tablet on his profile, not from her profile, thinking she was smart. Thinking that she was smart in order to communicate to him through his own profile. The only other issue is that when he had the communication received, it was not directly to him, but to that ex-girlfriend. And she notified him of the fact that his lady was communicating with her, like, get your girl away from me. And that's how he knew what had happened. He wasn't even aware that he was now being searched for. Well, that very same evening, that ex-girl had went with him to that very same hotel room. That hotel room was now in question because there was contact in violation of, of a protective order, in which in California, yes, he would be guilty of that. But the fact that she was searching him out after the criminal threat and communicating through his assets, which he was able to prove through using Google Maps, on the GPS location of his asset at the time of the communication. That GPS coordinate and that communication to him after the call to the police was one of the prongs that broke the statute of criminal threats. Because in California, in order for it to be a criminal threat, the party, or in order for it to be a criminal threat where the prosecution could charge, the party has to have a reasonable fear for their life. So you can't just call the cops saying, hey, I'm afraid. You can, but if you go back and communicate with them, then that's a problem. And she was incriminating herself through those communications for a false complaint. What had also transpired was that he was blocked from her phone because she blocked him earlier in the day. That was another thing that was against her. And he was able to prove that. Therefore, meaning that there was no communication that could have even been made directly to her. Her statement was that he called her from his phone. After he gets locked up a few days later, because they were just looking for him and they found him, what had happened is that when he was in jail, she had access to that tablet and started accessing his bank accounts, his PayPals. He had made purchases at his local Walmart. She was going around and picking up assets that he had paid for, that he never got the chance to pick up. When he had gotten out of jail, he went to go access his PayPal. And she had blocked him remotely by denying the access from that tablet because they needed an authentication for him to continue viewing. She kicked him out. He ended up calling the police over his assets because he didn't want to even see her. The police failed to retrieve the assets. She admitted, yes, I have them, but I don't have to give him anything. So the peace officer said, well, then maybe tomorrow we'll have to file charges. Maybe tomorrow instead of just going and retrieving the assets. Ultimately, she ends up driving his assets back to where he's at. And when she does, she leaves it, rings the bell, runs in her vehicle. He tapes everything, again proving that she was committing identity theft, was not in a reasonable fear for her life, and that she didn't have any proof, and he had proof of never communicating. In the state of California, if you make a false report, that is a chargeable offense. If you commit identity theft, especially through cyber means into someone's bank account, that is identity theft. Now, where does the Brady violation come in? The fact that he made a police report regarding all those issues would have indemnified him of the charges of the statute, but the prosecution did not want to address it. The police had the evidence. They did not notify the prosecution. They did not. Now, the prosecution had been trying to prosecute for a few months after he made the complaint. The police were not even sending the police report to the prosecution because of the fact that where he lived, he was prejudiced. Sorry to say, but he was prejudiced. The reason why he was prejudiced was because, one, he had a history of arguing with the girl, not beating her, but arguing, where there have been domestic disputes. Henceforth, why she had a restraining order. But she was still seeing and sleeping with him. And the problem with that also is the fact that when the restraining order was in effect, although he may have had liability, it proved that she did not really need the restraining order. The woman who was his ex-girlfriend was also a fact witness of where he was at all times, because immediately after they left that bar, she went to go see him because she started receiving those messages, which means that she had the tablet in the vehicle. All those things, along with a witness statement from his ex-girlfriend of where he was at that evening, because she went to go see him, complaining about being communicated with, which I should have said that earlier, but that's another element, was not being presented to the court at all, whether the prosecution knew or didn't knew, because those local police were prejudicing him because of, one, the history, two, he had a criminal record, and three, because of the fact that, again, he was being prejudiced. I'm trying to say that without sounding like a bigot, but it was the color of his skin, and no, he wasn't black. He was white in a brown town. Not saying anything bad about brown people. It's just, they were just looking at him like a loser. The other problem is that he's a foreigner to that town, meaning he comes from another state. They know this about them. So they were looking at him like, well, this guy right here thinks he's all that. Yeah, whatever. Because he was also arguing with the police for not doing their job, which made them not want to do their job. Where he's from, people are known to have tempers. So he wouldn't shut his mouth. Now, with that being said, ultimately, the prosecutor ends up catching wind. Wind of all the exculpatory evidence. The prosecutor starts breaking deals down. And when I mean breaking deals down, I mean lowering the deals. It went from 3 years of incarceration to 2 years, but he'll only do 4 months with a suspended sentence, to 1 year probation. And all he did was say, hey, leave me the fuck alone. Prove it. Unless you're going to reach into the space-time continuum and pull those molecular vibrations that came from my throat and my vocal cords through the atmosphere and into that cell phone frequency, hey, guess what? What are we here for? So the police's failure to give the prosecutor the evidence for that much time was a Brady violation. There was no investigation because there was no evidence. And all the things that they needed to prove his innocence, that there was no communication, along with her lying, along with an eyewitness, was enough investigation to begin with. The prosecution just didn't want to acknowledge it. The police failed to give it. And even if it was purposefully or not purposefully, the Brady violation was acted upon. There are other elements to the story, such as the fact that he did do the trademark process, which initially allowed for the collapse of the case because they saw that it was a weak case with no evidence. He was already bitching about Brady violations, and he did the trademark process to secure his out. It fell because the trademark process collapsed it. He was able to get compensated for a false arrest and the Brady violations. That is an example of Brady violations. The prosecutor either knows or doesn't know, but there is evidence that would indemnify the party from the charges, and they fail to fucking act. Okay, cool. Now that I said that all slow, now let me just talk regular. In a lot of CPS cases, mortgage cases, there are Brady violations depending on what it, well, not Brady, not CPS, I mean, not mortgage cases, but there are a lot of Brady violations that occur. It is up to you to see what evidence stops you from being liable of the wrongdoing. Present that evidence. A lot of times prosecutors cannot accept the evidence up front. You might need a police officer to counter the argument. The reason why is because they have to have an information agent to reach it. Unless you're at trial or you have pretrial. And sometimes you may have an attorney who might not want to assist properly. Let me give you an example of that. My friend had started with a female attorney for that case. She really, really didn't like him. She thought he was an angry guy. Being angry is not a crime. He had every right to be angry. He was pretty much framed for something he didn't even know existed. And he just gets wrapped up for charges he wasn't even aware of. Because she didn't like him, she didn't do her job. She didn't take anything he said seriously, and she would not present to the court any argument on his behalf of any sort. She just kept extending his days. She even failed to meet with him at times she was supposed to meet with him. She'd say, come to my office at 1. She wouldn't be there. Then she would come back and say, oh, I had to go to the dentist. Well, then why'd you set an appointment? You stupid thing. But now what happened is that he threatened her with putting up a bar complaint for ineffective assistance to counsel and for everything under the sun that he could think of. She then removed herself from the case. They gave him another lawyer. The other lawyer did not want to execute what he asked. He said, no. That other lawyer gave me ineffective assistance. I'm going to make sure you give me effective assistance. I need you to do X, Y, Z. That lawyer then passed him off to one of his lower lawyers and said, here, you deal with this guy. So the third lawyer was a lot more calm and collective, and at the end of everything actually told him, you know what, you're a good guy. You're not really an asshole like that. You're just adamant about what you were trying to talk about. And that's it. You were pushing your situation, and unfortunately, situations like this happens, blah, 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 blah. And you know, lucky for you, you didn't fall victim to it. There should have been no luck. I'm not going to disclose the amount that my friend was paid. But let's just say Brady violations create a scenario that you can capitalize on. You must check all parties. You must make sure that the evidences are there. You must show that there was a neglect upon informing the parties. The prosecutor can do it wittingly or unwittingly, but they will be in violation of Brady if, they will create a Brady violation simply by not presenting all facts. Okay? So that's a story for today. Now you see how the Brady violations can be met, meaning the requisites or the components of a true Brady violation can be met. The evidence at issue must be favorable to the accused, either because it is exculpatory, meaning that it indemnifies him, it shows that he didn't do it, or did do it, or she didn't do it, or did do it, because it's impeaching, it attacks the character of the witness or the claimant, that's what that is, and prejudice must have ensued. Maybe the police don't want to deal with you because you might have had a bad record, you might have had a bad traffic stop. They might just assume automatically that you're guilty because someone's crying or because an officer or agent said that they received a complaint and that they're just addressing it and nobody wants to unpack it because they're only trying to worry about prosecution points as opposed to justice being served. Y'all have a good day, and I hope you like this video. Again, this is Raymond De Leon with Smooth Operation of Law. Please like, share, subscribe, and inside of the description box, there is my messenger link. You can contact me on Facebook or on Messenger.